Supplementary cause list, item number 1 for pronouncement of judgment.
Petitioners are here. I'll read out only the operative portion. So, Mr. Debnath, I'm afraid I cannot help you. The proceeding was conducted with due respect to the concerned court. Without jurisdiction, and the manner in which it was proceeded. So, you have to take your chances. Let me read. Taking all aspects of the matter in hand to consideration, the relevant authorities cited by the parties also being duly considered, and those found applicable to the facts and circumstances of this case being cited, this court is of the considered opinion that the impugned judgment and order dated 2/2/2017 and the order for execution dated 3/12/2018 are liable to be set aside and quashed, which is done so herein. To the extent indicated, this petition succeeds. The impugned judgment and order and the order of execution being held to be invalid, the relevant parties can take necessary steps for recovery of possession if so advised. With the above, this petition is hereby disposed of. Of course. Thank you.
May it please your Lordship. Lordship, I beg to make a mention of item 14, Lordship. Lordship, a similar matter is pending before the division bench of this honourable court, Lordship.
That has not been decided?
No, Lordship.
On premier by the petitioner, this is matter after 3 weeks.
Obliged, Lordship.
May it please your Lordship. Your Lordship, I beg to mention item number 17, Your Lordship. The conducting counsel for the state, Mr. S. Sen, Your Lordship, is not available today due to some personal difficulties, Your Lordship.
17.
Yes, Your Lordship.
On pre-made by the respondent, not objected to by the appellant, matter is adjourned. This is the same after 2 weeks.
Obliged, Your Lordship.
May it please your Lordship. Lordship, I beg to make a mention of item number 13, Your Lordship. On behalf of P. Nongri, Your Lordship, for respondent number 4. I pray this matter may be listed after 2 weeks, Your Lordship, as he is on sanctioned leave, Your Lordship.
Yes, my Lord, he is all the time taking time. Last chance may be given to him. Otherwise, again, he will take after vacation. He will take.
I don't believe in last chance.
Right.
Because if I do that, it will be an embarrassment for you. Because the next time you will come, and then we have to invent something which comes after last.
Yes.
So we don't know. We have not yet come to that stage.
Some observation will be made, my Lord. Continuously taking time. That is the reason.
Who is the main respondent here? District Council?
I'm appearing on behalf of respondent 1 to 3, Your Lordship.
Prayer is made on behalf of respondent 4, seeking adjournment on the ground that the conducting counsel is indisposed as he is on sanctioned leave. Mr. H. Hazarika, learned counsel for the petitioner, has submitted that has no objection to the prayer made, but has, however, stressed on the fact that this matter has been kept pending from time to time on the prayer made by the respondent seeking adjournment. In view of the submission made, this court is inclined to allow the prayer. However, the parties are requested to be diligent and take up this matter seriously with an effort to dispose of the same, to get the same disposed of expeditiously. As prayed for, this is matter after 2 weeks.
Highly obliged, Your Lordship.
Please, Your Lordship, I beg to mention item number 10. I pray for 2 weeks' time, Your Lordship.
I think this was a part heard. That issue of limitation.
Yes.
Yes.
Yes. What do we do?
We have sought for time on several occasions. Anyway, we'll not let it.
The Red Counsel for the respondent has sought for accommodation in this matter on ground of personal difficulties. These may not be objected to by the appellant. It seems allowed. This is matter up to 2 weeks.
Deeply obliged, Your Lordship.
May it please, Your Lordship. Your Lordship, I beg to mention item number 19, Your Lordship. The Additional Advocate General, Your Lordship, Mr. N.D. Sholai, is indisposed, Your Lordship.
Let the matter come up because I wish to withdraw with certain observation. Let the matter come up.
Obliged, Lordship. From supplementary cause list, item number 2.
Yes,
May
Mr.
please, Your
Chairman.
Lordship. Lordship, this is a bail application with regard to the accused name Mercy. There are 2 accused persons in this case. Lordship, the accused person, they have been charged under section 21B and 29. And with regard to my accused person, it is concerned with 29. That's what they have framed the charge. Now, in the instant case, Your Lordship, she was arrested on 4th August 2023, and the FIR was lodged on 3rd, 4th August 2023. When we go through the entire FIR, there is not a whisper anything against my accused person. No and thereafter, my accused person was arrested on 4th August. Then they went to the resident of the accused person also to see, but they could not find any contraband items or any materials to connect her with the case, Your Lordship. And moreover, in this case, it is a case. It is not a commercial case. It falls under the intermediate quantity. Now, the accused person has been in custody for more than 6 months, and she's of a young lady of 20 years, and the materials which has been provided by the prosecution for the purpose of facing trial. Now, the CDR which they say to rely upon, which is not there available on record, no CDR report is available. They said through connecting with the phone and all, but like when they went to her residence, no contraband item was found, and the material, the basis on which they say that the accused person was charged, that material is not there on record. And moreover, the trial is proceeding in a very slow pace, and she has been in custody for more than 6 months. And under the section 437 or CRPC, the proviso, it provides also that when it is an accused person who is of a woman or a sick person, that proviso is also there that the accused person to be released on bail. And the embargo which is given under section 37 of the NDPS Act will not be applicable in the instant case, as it is not of a commercial quantity. The twin conditions which has to be followed, that it is not required to be followed, as Supreme Court, Your Lordship, is also very much aware about the law when it comes to small quantity and the intermediate quantity. The embargo does not apply here in the intermediate
Embargo
quantity.
may not be applicable. But
Yes.
the seriousness of the offence cannot be overlooked.
That is there, Your Lordship. So when we look at the seriousness of the offence, as Your Lordship has said, now the allegations, on the basis of the allegations and the materials available on record, also there is nothing on record to show that my accused person is connected in commissions of the offence. The allegations of recovery of the alleged recovery of contraband items is from the other co-accused person, where the accused police had an information as per their FIR and their report. It says that they had an information that the other Pramod Chetri is going to deliver some contraband items, and then when the vehicle was checked on the way, then it was found from his possession. But thereafter, they went to my resident, they checked everything, no contraband item was found. So I am neither in physical possession, neither in a conscious position or in a constructive position to show that I have a knowledge with regard to the contraband items which was alleged to have recovered from the other co-accused person. So the presumptions to be drawn under Section 54 of the Anti-PAS Act is not applicable in my with my accused person at this stage, and moreover, no evidence so far has come out against my accused person. So to put the accused persons inside the jail for a considerable period of time when there is no evidence on record to show that she is involved, and she is facing the trial, and the trial is facing in a slow pace, and that's why I am placing before this honorable court that this is not a case of a commercial quantity, and the maximum punishment, the punishments which is provided under Section 21B, it says that it may extend to 10 years, but it is not a case where the minimum punishment is 10 years or above like in commercial quantities. So the questions of granting of bail, it will be like any other, for the purpose of considering the bail, it will be like any other regular bail under the CRPC, like 439 and 437, the proviso which I have placed before this honorable court also. So Lordship, I humbly pray that this lady also, she's a very young lady, and this is the first case where she has been alleged to have been committed, and the first case where she has been arrested in any criminal case. She has no other any criminal antecedent. So I pray to this honorable court to kindly please to grant bail to the accused person on any terms and conditions, and she will abide by all the terms, Your Lordship.
Yes, who's appearing for the
and one thing, Your Lordship, if my Lordship may please to allow me, they say that the confessions which they made before the police, on the basis of the confessions what they have stated, but like there is though they say that the confession was made before the police, that this was brought from the connections was there, but like they have never sent to the magistrate for the purpose of the police has never sent the accused person, neither the accused person, my accused person, or the other accused person to for the purpose of confession before the magistrate. So any statement made before the police, that is not admissible.
You see, at the time of trial, it will not be admissible.
Lordship, I'm accepting notice on behalf of the state respondents. Lordship, the statement of the co-accused is not present, so which is necessary in order to find the involvement of the.
The charge sheet has been filed.
The statement is not there of the co-accused.
The statement is not
present
in the compilation.
Yes, in the compilation. Lordship. Which is necessary to.
But that statement is on record, or it is not?
It's not in the record.
The IO has not got his statement recorded.
Statements.
Well, this case is based on the very statement of the co-accused, where there is an allegation to the fact that the petitioner herein had handed over the consignment on a commission basis. So therefore, the statement of the co-accused will be required to ascertain the involvement of the.
Why. Now, what we are saying is that whether the statement was recorded or not. Number one.
It has to be, because on the basis of the statement, she was being arrested, being led by the co-accused, the man accused here. So lower court will
You mean to say, okay. You mean to say that in this petition the statement is not there?
No, it is not there.
These are the copies that has been.
The charge sheet has been. I have enclosed the copy of the charge sheet, and that's why Lordship, whether my accused person or the co-accused person, their statement under 164 was never sent to the magistrate for the purpose of recording. That's what they say. So that was never done, to your Lordship.
Now he's saying that it's there on record, but it is not produced before the court.
Yes.
charge sheet I have enclosed. I have enclosed the charge sheet, which is the relevant
Yes,
charge
because
sheet.
you see, in the along with the charge sheet, the statement under 161 and 164 ought to have been given to you.
Yes, sir.
164.
Okay, 164 it was never recorded, Your Lordship.
We'll ascertain that then.
Lower court record.
Local records not required, but you
Duplicates.
you
Duplicate charge sheet.
yes, you
We'll do that.
you get it from the court,
Yes, yes.
file a copy.
Lordship.
So we'll have to look into the statement. They say that the statement is there, you say it's not. So
164
the
is
records
not
has to be
there.
produced.
Okay, Lordship.
Or yes, the counsel for the petitioner was pressed for grant of bail on behalf of the
Name Mercy, Your Lordship.
petitioner is
Is the sister, Your Lordship.
petitioner is his sister.
Yes.
Gunung Tokong? Sister of the petitioner who was arrested initially in connection with Longpok PS case number 51-5 of 2023 under section 21 B under bracket B small b oblique 29 NDPS Act. The investigating officer, upon launching of investigation, has completed his investigation and a charge sheet was accordingly filed along with the final report. The findings of the IO is that where are the findings?
Bail order, Your Lordship.
The findings in the charge sheet.
Page 17, the charge sheet, Your
Yes,
Lordship.
yes. Gunung Tokong, findings in the prima facie case under section 21B is found under section 29 NDPS Act is found well established against the accused person named herein,
My accused is
and the case is now proceeding for trial before the trial court. It is also the submission of the learned counsel for the petitioner that the accused person, the accused sister of the petitioner, is not at all involved in the case and no offence is made out against her, inasmuch as there are no evidence to support the prosecution case as far as she is concerned. However, as far as she is concerned, under such circumstances, the prayer of the petitioner is for grant of bail to the said accused person with any condition that this court may be pleased to impose. Mr. Leonard, you are GA?
J. Thapa, yes.
Leonard GA, appearing for the state respondent, has submitted that from the papers enclosed with this petition filed by the petitioner, it appears that copies of the relevant statement, particularly that of the co-accused, is not available, when in fact it is on the basis of the statement of the said co-accused that the accused sister of the petitioner is found involved in the said case, and her complicity is also found well established. However, the learned GA has submitted before this court that the state respondent may be allowed to produce the relevant records, including the statement of the said co-accused, for consideration by this court. At this point of time, the submission of the learned GA is found reasonable, and accordingly the court would direct that the relevant copies of all relevant papers, including such statement, are produced for this court on the next date fix. As prayed for, let's this matter when?
1 week, Lordship. 1 week time may be given.
This is matter on 16.
Highly obliged.
Much obliged, Lordship. Daily costless, item number 1.
May I please, Your Lordship?
Yes.
Let this matter be taken up at the bottom of the list, Lordship, because Mr. Ashishek is in court number 4. Lordship.
End of the board.
Your Lordship.
Item number 2.
Your Lordship, in this case, I need some time to file my affidavit, Your Lordship.
What about the other respondents?
Other respondents?
Sorry, I filed respondent 3 and 4. We have filed.
You have filed?
We have.
So now only 1 and 2.
1.
Mr. R. Debna, learned CJC, appearing for the respondents 1 and 2 respectively, has submitted that he may be allowed to file the counter affidavit within the next date fix, as the same could not be prepared to be filed today. On premier, the same is allowed. Let the said counter affidavit be filed within the next date fix. This is matter after
3 weeks.
3 weeks.
Item number 3.
Lordship, 328 are those ROC matters. Lordship, in one of the case, we have already paid our fine. Now the ROC has to pass a formal order compounding. Lordship, some time may be given, Lordship.
The ROC has filed the, passed the order.
Lordship, we had approached them, we had paid the fine. Now he has to pass a formal order. I was informed that the concerned ROC is not in station, he's on leave.
He's on leave.
You are aware of these proceedings?
Proceeding going, this is evaluation. So now they are saying they have to make payment. So if they make payment, the formal order will come.
Yes, yes. Once that is done, then means the matters has done compounded.
Lordship, insofar as the item 7 and 8, these concern Manipur state. Lordship, because
so
of
this would be only with regard to item number
3 to 6,
3 to 6.
Now 7 and 8 also because of the situation in Manipur, Lordship. It's quite disturbing. So we are yet to allow 4 weeks time, Lordship. Because ROC is also on leave. He'll be back.
On premier by the parties. This is matter after 3 weeks.
3 weeks, Lordship.
Hello.
Item number 9.
Yes, Mr. Paul.
This is the matter where your lordships have heard us in part to an extent concerning this is a revision petition directed against the orders passed by the revenue board. Originally, there was an order passed by the deputy commissioner, which was taken in appeal before the revenue board, and against the orders of the revenue board, we are here before your lordships and our respondent number 1, members of the meantime, had passed away, and the lordships subsequently had deleted, we moved an application, and respondent number 1 has been struck off. Respondent number 2 is the main respondent. I was only praying if your lordship so permit, this matter can be taken up physically next week, September, and subject to the convenience of your lordships.
Look at the last order, Mr. Paul.
I've seen the order, which is why I'm ready with the matter. But this is a matter that I personally feel would be more appropriate to be taken up physically. Because lordships, what I would have to flag is there are two aspects to this matter. One is that the ground on which the appeal of the petitioner has been rejected is primarily saying that there is no locus standi of the petitioner insofar as to file the appeal before the appellate court. The reason why I say this is the land in question is very much in the possession of the petitioner. The lease is in his name. Now, initially, when the deputy commissioner had passed an order, we had raised a plea that under the rules, it is only the commissioner who has the power to adjudicate matters under Rule 26 and not the deputy commissioner. That aspect was never answered. That was carried on the appeal before the revenue board, and the revenue board has then come to a finding that there is no locus of the commissioner to file this appeal before the board. Now, these are two aspects which I will have to satisfy your lordship. So, any date, whether Tuesday would be convenient, I'll make it effort to conclude this matter.
Yes, my lord. I have no objection, my lord. Anytime next week. Already, my learned friend has already briefed the honorable court regarding the two stages which has already been taken place. One is the court of the deputy commissioner, and the other is the revenue board. And against the order of the revenue board, they have come before this court for this revision. So our stands are very limited. So any fine day they are ready, we are.
What I can do is, I'll have a small compilation prepared of the rules for your lordship's ready reference. These are very small rules, so that I don't have to burden your lordships with and with the judgments that we had relied on. All these will make a small compilation and place it before your lordships on Tuesday, and your lordship will conclude the matter.
At the hearing, it is it's up to you whether you rely on some authorities or you make a compilation. Of course, it's up to you.
These rules, are what has been relied both by the deputy commissioner as well as by the deputy. It is a question of interpretation of the rules, because under the Meghalaya interpretation of general clauses, interpretation of rules, it says it is the commission. Now that fact had been pointed out before both the deputy commissioner as well as the deputy board. Unfortunately, these findings were there. So I will just prepare that and place it on a compilation before your lordship so that it will be easier for you to adjudicate.
Heard learned counsel for the parties. Mr. K. Paul, learned senior counsel appearing for the petitioner, has submitted that before proceeding with the hearing of this matter, he may be allowed to file a compilation of relevant rules and authorities so as to assist this court at the hearing. The Mr. S. Sengupta, learned additional senior GA.
For respondent number 2.
For respondent
number 2.
For respondent number 2 has no objection to the prayer made. On consideration of the prayer made, in spite of the previous order of this court passed on 31/10/2023, the court would accommodate the parties, and accordingly the matter is now posted to be heard on the next date fix. As prayed for, this is matter after 1 week. 1 week's time will give you enough.
Item number 11.
May it please your lordship, and item 11, your lordship, we were to file an affidavit in response to the rejoinder that was filed by the petitioner, and the same was allowed by order dated 18/10 of 2023, your lordship. I'm praying for further 2 weeks time, your lordship, as instructions are still awaited.
But why would you file a response to the rejoinder?
Your lordship,
Because the rejoinder would be, in response to your counter affidavit.
your lordship.
And more often than not,
Your
it would not include new facts or law.
What happened was earlier, as submitted by the counsel for the petitioner, the annexures were not annexed in the affidavit. That was what was submitted, and then accordingly they filed a rejoinder after that. And I think on the last occasion we had prayed again to file the response to the rejoinder, your lordship, and that was also allowed, your lordship.
Then a counsel for the respondent has submitted that the response to the rejoinder affidavit filed by the petitioner could not be filed today, and as such, accommodation is sought for to allow the parties to allow the said respondent to file the same within the next date fix. On the prayer not being objected to by petitioner, this is matter. The same is allowed. How long?
2 weeks time, your lordship.
2 weeks. This is matter to 2 weeks.
Your lordship, and item 12 is also a connected matter. However, in this matter, pleadings are already completed, so our affidavit is only with regards to item 11, and 12 is also connected, so it can be listed on the same day.
12, as prayed for by the parties, this is matter after 2 weeks.
Item number 15.
Please, I have received the affidavit last evening, Your Worship. So I pray 2 weeks time, Your Worship, to seek instruction.
Then a counsel for the petitioner has submitted that the additional affidavit filed by the state respondent has been received only yesterday, and as such, some time is prayed for to seek instruction as to whether a response is required to be filed against such additional affidavit. Hello?
2 weeks.
On pre-meet, this is matter after 2 weeks.
Right.
Item number 16.
Well, it's in item 16. Respondent number 3 has now filed an affidavit. Well, it's, on the 30th, they have served us a copy.
Yes. So?
Well, it's, I would just have to take instructions whether we are required to file a rejoinder to this affidavit or not.
I think this counter affidavit was filed on the last date fix.
30th.
It was filed on
30th of November. Oh, sorry.
30th, yeah. 30th.
30th.
So,
Well,
what took you so long to respond to the same?
well, 30th, it was last week.
Even so, it is incumbent upon you. You see, if you wishes to file a rejoinder to the same, you could have done so.
My lords, your lordship, can you appreciate that the respondent number 3 all along was not participating in the proceedings? It is only now at this related stage after the matter had almost come up for final hearing, that's when the affidavit is come.
No, be that as it may, you see, the affidavit was filed.
True, lordship.
And copy was also received by you.
On 30th.
On 30th.
Yes.
So you wish to file a response, or?
We'll file a short response, but the short response will be filed.
Besides, my lord, respondent number 4 is yet to appear in this matter, my lord. The services have already been effected, but he has not appeared.
R4 is not.
R4.
Then we'll proceed ex parte. The service is completed.
Completed, my lord. We
And you
were
file your
required to
affidavit of
file an
service?
affidavit, my lord. That we could not do, my lord, because the petitioner is, my lord, has been sent to Chandigarh for his official duty, my lord. So he'll be back on 10th. I'm informed. After we'll file an affidavit after he comes back to Shillong, my lord. Otherwise, the services have been effected. That is what is shown in the status report.
Mr. Estapa, Mr. K. Paul, Learned Senior Counsel, appearing along with Mr. Estapa, Learned Counsel for the petitioner has submitted that the counter affidavit filed by the respondent 3 has been received by the petitioner, for which some time is required to consider as to whether a rejoinder to the same may be rejoinder to the same will be filed or not. Next, as far as respondent 4 is concerned, the learned counsel has submitted that the notice upon such respondent has been affected. However, the affidavit of service could not be filed, for which some time is prayed for the same to be filed. On consideration of the prayer made, this court would allow the petitioner to file the said rejoinder to the affidavit filed by the counter affidavit filed by the respondent 3 within the next date fix. The affidavit of service, as far as respondent 4 is concerned, is also to be filed within the set date. On prayer made, this is matter after 1 week.
2 weeks, Phillips, as my friend has pointed out, he's in training, Phillips. I will take some time for that.
This is matter after 2 weeks.
Item number 18.
Malus, in item 18, file an application seeking Malus waiver of the 5,000 rupees cost that was imposed. Your lordships on the last occasion had imposed a cost of rupees 5,000. Malus, we have made a small prayer before your lordships that lordships kindly consider whether it would be reduced to some. The judgment was sought on my behalf, Malus, by my friend.
Mr. Paul, you are well equipped to pay this.
No, it's not coming from me.
Anyway, we'll hear the matter today. I'll pass this orders.
No,
So please start.
So far as the main matters, I'm sorry.
Yes, please start with the main matter.
Fine. This is a review application.
Yes.
Now, the preliminary ground on which this review was filed was that the appointment order of the petitioner, of the writ petitioner. Seems to be a forged and fabricated document. That is what we had submitted. And on the basis of that, the lordships had initially asked an affidavit to be filed by the writ petitioner.
Yes.
It was by order dated 28/11/2022, your lordships had collected that.
28.
28/11/22.
Yes.
The only ground on which this particular review is there is that because we have alleged that a fraud has been played by the respondent number one before your lordships in these proceedings by relying on a document which we say is a forged document. That is not the actual document. Your lordships have thereafter directed both the parties to produce their respective documents. We have produced ours. They produced a photocopy of the document. To that extent, we filed an affidavit. And if your lordships, can we have that affidavit? Both those two documents are there. This is the affidavit filed on 6th of December 2022.
Yes.
No, this is my appointment order. If your lordships, can we have it? I'm sorry, this appointment order. It is, your lordships to find it at page 7.
Yes.
Your lordship to kindly see, it is 3. Then there is your lordship should have seen, there was something written down below, which was erased by using white ink, and then Siljon A. Sangma, PU is hereby appointed as head teacher on constituted pay of ₹3,000 only per month with effect on the lordship copy of information and necessary action, Francis Sangma.
Yes.
To that extent, our contention before your lordship is that, this is a forged document because your lordship will kindly appreciate that in a formal appointment order, why would there be an interpolation, and the name of the respondent number one be written in hand by putting white ink or something else, because I don't have the original with me, and on top of that, by hand, his name is written on there. Now, the entire foundation of this case is this, that if this document, the authenticity of this document cannot be proved by the respondent number one, you would not be entitled to any relief under Article 226 of the Constitution.
But who would verify the veracity of your claim as to whether this is pure or?
We are the managing committee of the school.
We are the managing.
Yes. We are the managing committee of the school. The writ petition was filed against the managing committee.
So you say that this appointment order is not in your records?
No, lordships, because your lordship will kindly see that it is why would somebody issue a formal order when lordships, it is apparent that there is some interpolation in this document. My humble submission as well as the onus then shifts on the respondent number one to prove the authenticity of this document. Because I am in review before your lordship, I cannot get into any other aspect of the matter. I would have to basically stick my case to only limited grounds of review available.
Exactly. Whether it's an issue of facts or whether it's an issue of records.
I am not a contesting respondent in so far as it is not a case that he should be given and I should be given. I am the managing committee of the school.
Have you met the petitioner party here?
Yes.
The petitioner in the.
Number one. He's respondent number one.
No, this.
John K. Sangma.
Yes.
Respondent number one.
Yes. And this Sengachi M. Sangma?
He is one of the present headmistress of the school.
Yes. No, this review was filed by the
writ petitioner in the writ proceedings. The writ proceedings, your lordships, we have annexed in our review application. I'll just take your lordships.
Yes. Now, Yes, it is the writ petitioner who have come before this court with this review. Now you are coming and saying that you are the managing committee.
My lord's writ petitioner and approached this court by way of writ petition for in relation to his services.
Yes, yes.
Now, there your lordship had disposed of the matter by passing certain relief to the writ petition. We, as the present headmistress of the school, has come before your lordship on behalf of the magic committee, pointing out that the very document on the basis of which he is claiming relief is a false document. It's a fabricated document.
Yes, Your Honor.
Well, if your lordship can have page 25, it will clarify the position of the review petition.
When you look at the cause title, at page 23, okay, represented by, yes, 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 please continue, Mr. Bhatt. I just want to confirm the, the status of the party.
Lordship, page 25 of the lordship. This
Yes.
is where this document comes in at paragraph 3.
Yes.
That under the initiative of the petitioner and with the help of the village elders, an upper primary school was established in the village and with a view to educate the 4 Garo scheduled tribe children in the entire area, and a managing committee was constituted to manage the school. And subsequently, the managing committee appointed the petitioner as headmaster of the school on a consolidated pay of ₹3,000 per month from the date of joining so by order dated 18/1/2000, and the petitioner duly appointed to the post, and since then he has been continuing as the headmaster of the school. Now, this is that document at Annexure 2, and that your lordship will find at
Yes.
And just bear with me for a second, because I'm doing it through these technical things. Turning pages becomes a difficult. At page 47.
Yes.
Your lordship will see.
Yes, it's there.
So, well, the authenticity of this document would have to be established by the writ petitioner before your lordships for any relief to fall from your lordships. And the relief which has been granted, I can very quickly take your lordships what your lordships have finally directed after hearing all the parties in the initial round of litigation.
Yes. That will be.
Well, at page 143. The judgment passed by the Honorable Court on 26/2022 is at page 143.
Yes.
The operative portion, starts from page 147, paragraph 14 onwards. Having heard the submissions of the parties on the face of it, this petition merits consideration as the impugned termination order was passed without affording any opportunity to the petitioner to respond to the allegations made therein. The proper procedure has not been followed by the Scotland Magic Committee, and however genuine the grounds for termination may be, for which this court may not enter into discussion of the facts therein, the principles of natural justice having been violated, the impugned termination order must be set aside. The contentions of so with regard to the eligibility of respond of the court to both the post of headmistress of the school cannot be looked into by this court at this juncture. since the main issue involved is the legality or illegality of the said impugned order. And again, the preposition of the learned additional senior government advocate that the response is directed to dispose of the restrictions of the petitioner cannot be sustained that the response is a number of years have elapsed. Well, that is not relevant. What your lordships have done is, basically there was a termination order. The lordships have set it aside, and thereafter your lordships have restricted your lordships only to that limited.
Yes, yes, yes. So only on the ground that the same was not, the procedure was not, principle of natural justice was violated. So there is no issue or no finding as to the authenticity of the, the appointment letter, as you have rightly pointed out.
This was not even flagged before your lordship.
So that, see, now.
At the initial round of litigation, it should have been flagged, but it was never flagged before your lordship. That it should have been pointed out, that
And you have also not filed in your pleadings, alleging that the same is not authentic.
At that point of time, it was not done. I would say that there was probably a little lack of assistance on the part of the respondents in assisting this court while this judgment was delivered. Because the foundation of the entire case would have to merit any relief from the normal court, the petitioner would have to first prove that he was indeed appointed in the school.
Yes.
Now that fact, in the initial stage should have been pointed out to your lordship, but it was never done.
And it would have been, you see, it would have been incumbent upon you to point out to the contrary.
Absolutely.
What do we do? I don't think a case for review is made out. See, the fact being that this court cannot prove the authenticity or the fact that the document in question is a forgery. This court is not competent to that. Either you or me cannot, you see, by merely looking at it, come to, we may assume, but we cannot authenticate it or cannot come to that. The process of forensic examination has to be undertaken.
No, what I'm submitting is a little different. What I'm submitting is the managing committee before your lordships is saying that this document is a forgery.
That has to be proved.
It is not. Our records would have to sustain any issuance of any appointment order. If it is not there, any document to the contrary would naturally be a forgery.
Have you produced your record?
Yes. The records are all available with us. We can place it before your lordships. Our magic committee records, right from the inception, we've got for it, which is there.
Okay.
We file. Our records do not sustain them.
Yes. Even so, Mr. Paul. Anyway, apparently, see, on the face of it, it would appear that the said document is suspect. But neither you nor this court can come to a definite conclusion as to whether, you see, what was the reason, you see, such thing has happened, whether it was a genuine mistake, or whether it was done intentionally.
We are supposed to be the authorities who have issued this order. Your lordship will see Francis Sangma is acting as your lordship will get Francis Sangma, who is the signatory of this letter.
But at the relevant point of time, Mr. Paul, as you have candidly admitted, you have not pointed out this this defect. You are the managing committee. These are this record is in your possession. This was also filed by the petitioner before this court.
It was filed by it should have been brought to your it was not done. Because I would humbly submit that this was fundamental to the issue.
Exactly.
my lords, which is why, my lords, the review proceedings before your lordships of this.
But you see, the findings of this court is on a different issue altogether.
It is on the issue of natural justice, my lords, I bow down. Your lordships are very categorically held in Paras 17 and 18, but that it is because only on the issue of natural justice your lordships are delivering that judgment.
Anyway,
The records, my lords, we just file it with the court master to assist your lordships.
please.
These are registers. These are the issues for registers, my lords, containing the minutes of the meetings of the marriage of the meetings.
So from the records, you just point out, you see, what are the relevant portion for which this court has to.
We'll back out that particular year.
Yes, Mr. Jarika.
May I please, your lordships? In the review petition, my lord, only the question he has raised that we have not challenged the order, appointment order of the review petitioner, whereas we have already challenged in our writ petition, my lord. That is only the reason has been shown in the review petition, my lord. And another question.
You have to, you
yes.
just have to convince this court
Yes.
that there was no error apparent on the face of the court.
Yes. There is. Now I am coming to that point, my lord.
Fine. So
and on the basis of the Honorable High Court order, we have produced the original, both the parties before the court. So after seeing that, both the appointment letter are shown exactly the same. Now they are raising the question of it is a false document. It should be in the initial stage, my lord. That is a disputed question of fact. If it is not, suppose it is a fact document or the false document. If it is false document, he is not the teacher of the schools. If he is not the teacher of the schools, then how they have terminated from the respondent here, petitioner, writ petitioner, from service? Without any reason, only the reason they have midday meal misappropriated by the petitioner, writ petitioner. Only this is the reason, without showing any notice, without giving any opportunity of being heard, and as per the, it is already here, my lord, they have to get the approval. Prior approval is a must for terminating a teachers. It has not been done. Government has not filed any affidavit because it is not on record. Now, in the writ petition, my lord, they have not raised this question, and in the review petition, they cannot raise this question in the review petition, my lord. So, what my learned friend is arguing, it should be rejected outrightly, my lord, because there is no reason shown. Because as per the CPC, my lord, matter is clear. Review petition. What is section 144? Review, my lord.
Section?
Section 114, my lord. CPC.
Yes, what does it say?
Yes, my lord. Subject aforesaid, any person considering himself aggrieved by a decree or the order from which an appeal is allowed by this court, but from which no appeal has been preferred. They have not preferred. By a decree or order from which no appeal is allowed by the court, or by a decision on a reference from the court of small causes, may apply for review of judgment to the court which passed the decree or made the order, and the court may take such order reason as it think fit, my lord. My learned friend has could not see this any defect of this order, my lord. There is no mistake in the order, because there is clerical mistake or something is missing on the basis of writ petition and the affidavit filed by this review petitioner, my lord.
Yes.
They have never raised all this question, my lord. Now they are asking this question. It has got no foot to stand, my lord, as per law, my lord, according to me. There is no mistake in the order, my lord. They could not point out anything. Only they are raising another question which is not relevant in the review petition, my lord. Only telling this appointment is false. If it is fake or the false appointment, how a person can continue in the service for more than 16 years, my lord?
That is exactly what we're saying.
No, that is another question. 16 years and managing committee is, they are all the record with them, they are paying these things, my lord. Even during his time, my lord, who is taking the review petitioner, now become the headmaster after termination, he is also there. Never raise any question. No managing committee. Now they are coming, new managing committee, my lord. It is a continuous process. It does not mean that anyone will come and alter everything. It cannot be allowed, my lord. It cannot be. Managing committee never die, my lord. One will expect, another will come automatically, my lord. It is never die. So it cannot be challenged like this, my lord. So my humble prayer that review petition may be rejected, my lord.
You see, the scope of a review petition is very limited, as we all know.
Yes, my lord.
This court will consider the submission made and whatever.
Yes, my lord.
I am only on one thing, since my learned friend has read out section 114. 114 is the parent provision for a review. We are not here before your lordships only on the parameters of 114. Now, Order 47 minutes lays down the three conditions for review. Your lordships are aware. I am not on that. Another fundamental principle of law is, Millards, that fraud on court vitiates everything. And, Millards, it has been repeatedly held that if there is a fraud played by any party to the court, the remedy open to the petitioner is, Millards, to go back to the court and point out that these are the issues, this is where the fraud has been played upon this court. Which is why, Millards, this review has been filed before your lordships. So I would not be certainly bound by these three parameters of Order 47. Yes, the scope of review will be very limited, but it is also settled law, Millards, that if there is a fraud played upon court, it ends any relief to the petitioner. Which is why I am again harping on the issue, Millards, that it is fundamental to the issue. It should have been taken at the initial round of litigation. It was never done. That is an error on our part. But when it has come to light, Millards, I have to come back before your lordships and point out that this document is not part of our records. It appears to have been forged, and which is why I submitted, Millards, the onus will then shift upon the writ petitioner to satisfy this honorable court that yes, this is a qualified and it is a valid document.
If you have any authority, in that regard, have you cited any authority?
I'm sorry,
Have you cited any authorities?
I'm sorry, I'm not equipped with that right now. I'll have that file. I'll supply a copy to my learned friend. But that your lordships are aware.
You should have that. You see, as far as the proposition is concerned, this court is aware. The provision of law is very clear. Principles are very clear. The only scope that this court will look into is whether, under the facts and circumstances of this case, a review is made out or not. To that extent, the court will agree.
As I submitted to my lordship, I am not strictly under Order 47 rule, Order 47 minutes. I am rather on the issue of fraud on court. If it is a case of fraud on court, I have to come back to my lordship.
So you come up with the relevant authorities then?
The two authorities, I will supply copies to my learned friend and file it to the court.
Do you have it with you, Mr. Thapar?
Not now. Kindly give us some time out.
We'll do it in the course of the day.
So by Monday then?
by Monday.
Mr. Hajarga, if you also have any authority?
No, here, my lord, these are
As far as the proposition of law is
Yes,
concerned,
yes,
if
yes.
you have any authority to back up your contention, do so. Heard and counsel for the parties. On conclusion of the hearing, the prayer is made for relevant authorities to be produced before this court, which could not be done so today. Accordingly,
as well as state respondent, my lord, so it can be verified because all the documents are in their possession now, so they can alter anything. So if it is as well as from the state, my lord, because state, every document with the state they have to supply managing committee. So state
they have the records.
just to verify.
But the state is not a party here.
It is party.
They are a party. They
Who
are
is
a
appearing? Oh, state is a
none
party.
has appeared.
Then why was the state not appearing today?
Mr. Groom. He's here, I think.
All along, I thought it was only between
Yes, ma'am.
the relevant parties.
State are also a party. State.
State is very much part. I'll just take it. State is R1,
R2 to 7.
R2 to 7.
Yes. And why no representation has been made by the state?
No, well, they have got nothing to say, my lord.
No, but
Yes,
they
my
should have been here.
Yes.
You should have.
They would have copies of all the documents, so they would definitely have something
So
to say.
if records are to be called for, and if the records is in their possession,
Yes.
then they have to be here to be
Yes.
to be able to assess the court.
Yes. He was very much here.
At the outset, Mr. Paul, you should have pointed out this.
Well, I'm sorry, but my vision is a little restricted. I thought somebody from the state was here. We can't see who's sitting next to the third council standing next to Mr. Hazarika. So I was under the impression.
Yes, Mr. Karwanlang. Look at the petition. The state is very much a party here, and you are
The state has appeared also. The state has appeared.
you are a very senior counsel on behalf of the state. You should have been able to assess the court.
Brief with this case. Also, if my lordship grants me some time, I'll.
Now we are back to square one.
Lordship, this matter is not handled by me, lordship. I'm not aware.
You mean I understand.
Lordship.
I understand.
Otherwise, I would have.
State has been appearing in this matter all along.
But who?
So I think today he might have. I thought he was here for us.
The-
Your lordship,
pass-
this
pass-
is matter
pass-
of public delegate for the authorities.
Heard the counsel for the parties. It is also pointed out that the state is also a party. State respondent is also a party in this case. However, none has appeared on behalf of the state respondent. Accordingly, then this hearing cannot be concluded today. Then. Accordingly, yeah, of course, as far as you're concerned, fine. Accordingly, the state is allowed to be heard in this matter on next date fix. List this matter on 15th. Please, Mr. Kumar, just
the grant council accordingly.
Much less.
you keep
Your lordships will just hear the state.
you keep the records with you
Madam.
as and when required. Then they'll be taken on board.
Madam.
In the meantime, we'll flag the record.
Please do, and the authorities.
Yes.
Mr. Ajay.
Item number 19.
Your Lordship, during the course of hearing on the last occasion, I had placed the latest judgment of the Supreme Court. The case of Zuniat versus State of UP and others. I think I placed it before, Your Lordship.
Yes.
I still have a copy of it. My Lord, will come to para 11 because there is a subsequent development. My Lord, when we had filed the revision petition, this judgment was not before us. Okay. This has been passed, in fact, only on
29th August.
29th August. So the position has been made very clear. My Lord. Para 11. In view of the above, there remains no shadow of doubt that on the receipt of the police report under section 173 CRPC, the magistrate can exercise three options. Firstly, he may decide that there is no sufficient ground for proceeding further and drop the action. Secondly, he may take cognizance of the offence under section 191B on the basis of the police report and issue process. And thirdly, he may take cognizance of the offence under section 191A on the basis of the original complaint and proceed to examine upon oath the complainant and his witnesses under section 200. It may be noted that even in case where the final report of the police under section 173 is accepted and the accused persons are discharged, the magistrate has the power to take cognizance of the offence on a complaint or a protest petition on the same or similar allegations even after the acceptance of the final report. As held by this court in so and so, a magistrate is not debarred from taking cognizance of a complaint merely on the ground that earlier he had declined to take cognizance of the police report. No doubt a magistrate, while exercising his judicial discretion, has to apply his mind to the contents of the protest petition or the complaint as the case may be. Now, Your Lordship, we are before Your Lordship because the magistrate, the learned magistrate, on our application file for review, because the FR was accepted by the magistrate on the ground that I did not file any protest petition, or rather I was not present on that particular day. So the FR was accepted by the magistrate. Subsequently, we filed an application to allow us to file the protest petition. And the learned magistrate has passed the impinge order saying, no, I have no power to review my earlier order. But by this judgment, my Lord, it is very clear that even after the magistrate has accepted the FR, I can still file a...
Yes, you can still file a complaint.
I can still. So, my Lord, I want to withdraw this petition on the on the ground that I may approach the magistrate. My Lord, will just record that in view of the judgment passed by the Supreme Court, I may be allowed to withdraw the petition and to...
My Lord,
that is,
I have no objection.
Heard Mr. T.T. Dingwal, Learned Senior Counsel, appearing for the petitioner, who has pointed out that in course of these proceedings, a judgment passed by the Honorable Supreme Court in the case of Junior versus State of UP and others, 2023 SEC Online SC 1082, which order was passed on 29/8/2023. Pointing to the said judgment, the Learned Senior Counsel has led this court to the observation made at para 11, which reads as follows. In view of the said observation, the Learned Senior Counsel has submitted that he may be allowed to withdraw this petition with liberty to file a fresh complaint before the magistrate if so advised. Ms. R. Colney, Learned GA, appearing for the state respondent, has no objection to the prayer made. Accordingly, without going to the merits of this matter as prayed for, petition is hereby dismissed as withdrawn with liberty sought for allowed.
Learned additional AG on the last occasion has raised a very pertinent point regarding whether the private respondent, rather the accused, should also be made a party in view of 401. Was that we'll leave it for a different occasion.
Yes, let the first let the magistrate take a call.
Yes, yes. But that was also a very interesting.
That would be interesting.
Yes.
401 has to be looked into. Yes, thank you.
Second call from daily cost list, item number 1.
Yes, Mr. Sheikh, what is this matter about?
This is Lordship bail in NDPS case, that intermediate quantity Lordship. That is this charge sheeted case Lordship. This is the second bail application Lordship. And the first bail application, while rejecting my prayer Lordship, Lordship has granted some liberty if that evidence is not laid within a period of 3 months.
Okay.
Then liberty is granted to me to approach this honorable court for consideration of the bail. Now Lordship, within 3 months, what happened Lordship? Then the evidence of one prosecution witness, only the examination in chief was held, but the cross was reserved, and cross is yet to be held Lordship. And the next 2-3 times they have adjourned for cross Lordship. Now Lordship, here apart from that Lordship, the accused twice she collapsed in the the jail, and thereafter she was shifted to civil hospital Nongpo Lordship, and she is a lady Lordship, and more than 1 year has been she has been inside the jail Lordship. Now there are various High Court has granted bail Lordship. I am relying to judgment. One, that Calcutta High Court judgment, the division bench, and matter travel up to Supreme Court. Supreme Court also did not interfere. So far as the regard of section 37 is concerned, also they have said that Supreme Court also said that that is not applicable in the case if the quantity is intermediate.
Yes, of course.
Yes, that is. Now Lordship, here is my Lord, see the punishment Lordship. See the punishment, because I am charged under 21B and 29 of NDPS Act. Quickly if I read out Lordship.
Yes.
21B Lordship.
Yes.
Where the contravention involves quantity lesser than commercial quantity but greater than small quantity, with rigorous imprisonment for a term which may extend to 10 years, and with fine which may extend to 1 lakh rupees. Now Lordship, since the regard of section 37, if it is not applicable with regard to the intermediate quantity, now Lordship, kindly appreciate one thing. Minimum punishment has not been prescribed here. The maximum is 10 years Lordship. Now tomorrow, assuming that I have convicted Lordship, but not considering Lordship. Now, since the minimum has not prescribed, the court has every discretion, has got the discretion to put any punishment lesser than 10, maybe 1 year or 2 years, whatever may be. Now, since I have served more than 1 year Lordship, and I am a lady Lordship, and with regard to the lady, that 437 Lordship, that there is some exception is cut out. I am not going on to that Lordship. My Lordship is well ever Lordship. So my humble prayer is that I am ready to cooperate. Only one witness, that also not yet completed Lordship. And I am seeking the liberty which my Lordship has granted to me while rejecting my bail application. And apart from that, I am sick. That will be available. The record will be available in the prison, that is in jail authorities Lordship, because from there I was shifted to Nongpo and I was admitted twice and discharged from their Lordship.
Okay.
Now Lordship, with regard to that issue Lordship, I am relying two judgment Lordship. One is Delhi High Court Lordship. In the Delhi High Court judgment, this is a single bench judge. He has referred so many bail order by the coordinate bench. Then Lordship, 1 Calcutta High Court, the division bench, Lordship. Here the bail were granted not even 5-6 months also, because they have interpreted the section 37 that the regard is not applicable in with regard to the intermediate quantity. And in that Calcutta High Court judgment, Lordship, he has history of criminal records, Lordship. 52 cases has been pending, but still the Calcutta High Court has granted bail. Then after that matter,
you're referring to this case or you're referring to Calcutta?
Another high.
Before you refer, you should at least give the court a copy.
Even the other side.
Yes, you have to give them.
I'm not even aware, Lordship.
I can give citation, Lordship, then.
You should give a copy to them.
That Delhi High Court judgment, not that long, Lordship. That is, I am referring para 4, 5, 6, 7, 9, 10, Lordship. And that Calcutta High Court, Lordship, this is a division bench order. Here the same offence, Lordship, section 21B 29.
Yes.
The Calcutta High Court also interpreted section 37 with regard to the regard, whether it will be applicable in intermediate or not. When the bail was granted, the state of West Bengal preferred appeal before the Supreme Court. Supreme Court did not entertain, Lordship. That is, I am SLP was displayed.
What is the relevant paragraph you are referring from here?
Here, Lordship.
The case of Calcutta?
Calcutta will be, Lordship, 5, 6, 14, 15, Lordship.
Yes.
Here, Lordship.
And where is that Supreme Court order?
That with regard to the regard, Lordship, 54, Lordship.
Where's the Supreme Court?
Yes,
Oh,
Lordship.
excuse me. Excuse me.
That they have said that 37 is not applicable with regard to. That is just, I am showing that matter went to the Supreme Court, then dismissed, just only for dismissal, because the Supreme Court did not interfere.
Yes.
My only prayer, Lordship, since I have been inside the jail, and for quite long time, Lordship, and it will take time to complete the trial, Lordship. At this stage, I only pray that any condition, Lordship, any condition, strict condition, Lordship, and I do not have any criminal incident and antecedents, Lordship, and the article were not found in my possession, Lordship. It was in the vehicle, not the physical possession, Lordship. That is also one of the grounds for seeking bail, Lordship. My only prayer that any terms and condition, Lordship, my.
Yes.
May it please your Lordship. Lordship, in the first instance, my friend had made a submission that the accused person was hospitalized. Lordship, that was 1 year back, as per the records we have received, Lordship. If I may just read to your Lordship. On 7th of October 2022, Lordship, the accused person and escort party led by so-and-so to PS after ME, on obtaining medical report, learned that accused person, Bina Sarkar, is physically and mentally fit. That's the first report, Lordship. With regard to the hospitalization, my lord, the the accused person had arrived and shifted to hospital, and this was on 8/10/2022, my lord. That was a year and a month ago. 1 year, 1 month back. 8/10/2022, lordship.
Yes.
The MO on duty opined that she is unwell with breathing difficulty and advised hospitalization for further investigation of her physical condition.
Yes.
Now, my lord, on 11/10/2022,
Yes.
it is to be noted that received telephonic information that the accused person, Bina Sarkar, will be discharged from Civil Hospital Nongpor. Accordingly, a prayer was submitted for taking over the accused person. All this happened a year back, lordship. This is with regard to the first submission made by the council, my lord. With regard to the second submission, lordship, pertaining to the order passed by this honorable court, and this will have relevance to the third submission made by the council just now, whereby they stated that no possession was found from their physical body, lordship. In the order passed by this honorable court, at paragraph 9, my lord, the order passed by this honorable court on 25/7/2023 at page 11 of the bail application, my lord. Annexure 2.
Yes.
At paragraph 9, my lord. Be that as it may, prima facie, the accused person having been found to be in possession of such alleged contraband goods, it would be a matter of evidence to prove her innocence, lordship. This is in response to number 2 and number 3, and in furtherance of what they have submitted. The second submission, lordship. At paragraph 11, before parting, this court would request the trial court to expedite the trial of the case, and if at the end of 3 months evidence has not been led, the accused person is at liberty to approach this court for a fresh look on any prayer made for grant of bail, if any evidence has not been led. My lord, as per the annexure 3 at page 15 of the bail application, lordship, my lord will see on 5/10/2023,
Yes.
in chief of PW1 was completed before 5/10. Annexure 4, 1910, again, cross-examination was not taken up. And we have received information from the public prosecutor, lordship, that on 1st of November also, cross-examination was not taken up. The delay was caused by the defense, lordship.
Okay.
My lord. As such, these 3 grounds made by the council should not be entertained by this honorable court, because on record, their statements have been proved to be wrong, my lord. And lordship, these are the only ground that they could have come, that the door has opened for them before this honorable court, is if evidence has not been led. My lord, evidence has been led, lordship. And with regard to conviction or not, that's a matter of trial, lordship. We cannot say anything at this stage, lordship.
Evidence to be led
My lord.
before the court, that is...
Exactly, my lord.
That is subject matter of the trial.
But the only door that open, lordship, is that if evidence has not been led, and my lord has seen on record at annexure 3, annexure 4, and our telephone conversation with the public prosecutor on 3 occasions, only what we are seeing, my lord, on 3 occasions, cross was not taken up by the defense counsel. So the prosecution is doing their job, my lord. And I pray that this honorable court will allow the prosecution to continue doing their job.
My lord, what my friend is saying, that on 1st November, that cross was not done because of my fault, lordship. If the witness is not coming, lordship, 1st November there was no witness. Then subsequently the matter was fixed. Earlier, yes, lordship. Then matter was fixed on 15th of this month, lordship. I can show the orders. Order says, lordship, the UTP so-and-so, Bina Sarkar so-and-so, so-and-so, so-and-so. The accused person stated that he so-and-so, that A. Mahmood, learned public proceeding present, the so-and-so, the case is fixed for cross-examination of PWN. No witness is present, lordship. That is 1st November 2023, lordship. And so far is that medical condition, lordship, I am also admitting that is prior. What has happened now recently, lordship, that records will not be available with the IO. because he is inside the jail, Lordship, because the case is already been charge sheeted. Whatever has been done by the jail authorities. My submission was not that he fall down before the filing of the charge sheet. She has recent, Lordship, not even 1 or 2 months after the
Recently, she has been hospitalized.
Yes, twice from the jail authorities, Lordship. And records will be available with the jail authorities, not with the IO, Lordship, because the charge sheeted case, after charge sheet, that nothing will be with the IO. So that is why I said that everything will be the jail authorities, Lordship.
My lord, they were at liberty to append any medical record with the application, Lordship.
How will I get, Lordship? Because they will do. It is not that I on my own way.
You could have applied. How you will get?
Now, if my lord...
We don't know, yes, of course, that is also...
Lordship, this is a matter of trial, Lordship. Now, since I have been inside the jail for more than a year, Lordship. This is intermediate quantity. It is not that what my friend is saying. It is not that this honorable court is granting bail. Other different high court also. I have so many judgment, Lordship, by different high court. If the accused is inside the jail for nearly 1 year or even 6 months, 7 months. So I just, since the Delhi High Court judgment has referred so many judgment, Lordship, so many orders that has been granted. And Calcutta High Court I am referring because the revision bench order, that matter went to the Supreme Court. Even Supreme Court also did not say the 37 regard is not applicable. That allowed. And that also not even 6 months, 7 months also. So my...
Yeah, I'll go to this judgment.
Yes. Oblige.
Oblige, Lordship.
So, what the parties are passing over.
Oblige.
Much obliged.